Hey folks, James Abrinio coming to you from Abrinio Cho. We are a personal injury, medical malpractice, criminal defense firm here in Northern Virginia. I typically use this channel to talk about Virginia law, policy, current events, dealing with criminal law, civil law. But if you have been following this channel for any period of time, you may know that I served as a citizen commissioner on our redistricting commission, which is unique. That amendment passed. First of its kind commission. I'd hoped that redistricting was something that was in the past for me, but unfortunately, mid-decade, it has now come under scrutiny, come back to the fray, because none other than our president, Donald Trump, has demanded Texas and other states redistrict in his favor to protect his majority, using language like he's entitled to seats, that kind of thing. In response, states, including Virginia, have now decided they're going to try to redistrict in response. I was hoping that the Supreme Court would step in and say, Texas, you can't do this. I was hoping they would say that partisan gerrymandering, which effectively, especially in Texas, becomes racial gerrymandering, is inappropriate. This is not the way our constitutional system is meant to work. We should not have a sitting president demanding redistricting to benefit him. But unfortunately, that didn't happen. And so I was a little bit curious, and I wanted to take a look at the opinion itself, just to see kind of what we're looking at, what their opinion was. I expected it to be a long opinion. Turns out that it was an opinion issued on the now infamous shadow docket. And along with that shadow docket opinion order, which I'm going to show to you, there was a concurring opinion signed on by a couple of the justices, as well as a dissent signed on by a couple of the justices along party lines, as you can expect. So I figured I'd review that with you all just to see what we're looking at. But to get there beforehand, I also wanted to review an important case that this same Supreme Court effectively said that the Supreme Court cannot get involved in partisan gerrymandering. They can't litigate that issue. And then they use that opinion then to justify not stepping in and stopping Texas. So, irony is dead. It's essentially quoting yourself. I always think of it as you're writing a term paper and then you quote yourself. It's kind of, if it wasn't so sad, it'd be funny. But let's take a look. The case that I was referring to is Rucho versus Common Cause. This is out of October term 2018. And let me zoom in this a little bit. So this is kind of where it all started. And to be clear, I don't practice the Supreme Court. I've never argued in front of the Supreme Court. I've dealt with Supreme Court opinions because in law school we learn about them and we read them. Doing criminal defense, you learn and read a lot about some of the constitutional amendments, and so you're inherently running into Supreme Court opinions. But this is not something that I deal with on a daily basis. I'm really, in a lot of ways, looking at this as a layman rather than an expert. Just because this stuff's complicated, but there's really simple questions I wanted answered here. So I figured let's just take a look at what the opinions are saying. And so looking at Rucho, I think is really informative. And just to be clear, this is effectively the same Supreme Court that has come up with this Texas opinion that we'll review in a moment. And just so you'll see the justices that have made this opinion. Roberts delivered the opinion, Justice Thomas, Alito, Gorsuch, Kavanaugh, and then obviously in the dissent, Kagan, as well as Ginsburg when she was alive, the late Ginsburg, Breyer, and Sotomayor. Breyer is no longer on the court. And I'm not going to go through this whole opinion. I'm just going to do a quick review of the syllabus, and then we'll move on from this. But this was, as you'll see, voters and other plaintiffs in North Carolina and Maryland filed suits challenging their state's congressional districting maps as unconstitutional partisan gerrymandering. So they're saying here, look, this is illegal political map drawing. Okay, that's what we're looking at here in Texas as well. So that's the reason it's kind of on point. So, and apologies. Let's see. The North Carolina plaintiffs claim that the state's redistricting plan discriminated against Democrats, while Maryland plaintiffs claims that their state's plan discriminated against Republicans. So you have both sides here on different states. The plaintiffs allege violations of the First Amendment, free speech, Equal Protection Clause, and the 14th Amendment, Elections Clause. District courts in both ruled in favor of the plaintiffs, and the defendants directly appealed directly to this court. So What that's saying is the states, the district courts in both Maryland and North Carolina are saying, this is not cool. You can't do this. This is playing games. And so they stepped in. And so, again, we're not going to go through the whole opinion. I'm just going to highlight a few, I think, important quotes from the syllabus. So you can, and I'll link this to the show notes. You can take a look at the opinion yourself. The opinion's 72 pages, so we just don't have the time. Partisan gerrymandering claims have been proved far more difficult to adjudicate, in part because a jurisdiction may engage in constitutional political gerrymandering to hold that legislatures cannot take their partisan interest into account when drawing district lines would easily countermand the framers' decision to entrust districting to political entities. And what it's saying is, look, any sense of political gerrymandering is not illegal. You can take that into consideration, and you can already see the court stepping back and saying, look, it's hard to look at. Let's not forget the fact that the court deals with very complex opinions. I mean, it's supposed to be the most highly sophisticated court with the most highly sophisticated justices in the country. But they're saying here, we can't, this is too complicated for us. So you can already see where it's going. The fact that the court can adjudicate one person, one vote claims does not mean that partisan gerrymandering claims are justiciable. This court's one person, one vote cases recognize that each person is entitled to equal say in election of representatives. It hardly follows that from that principle that a person is entitled to have his political party achieve representation commensurate to its share of statewide support. Vote dilution in one person, one vote cases refers to the idea that each vote must carry equal weight. The requirement does not extend to political parties. It does not mean that each party must be influential in proportion to the number of supporters. The racial gerrymandering cases are also an opposite. They call for elimination of racial classifications, but a partisan gerrymandering cannot ask for the elimination of partisanship. Again, in a two-party political system where you run as two-party system, obviously how those parties are impacted have an impact on each individual vote. But again, the court is stepping back there and saying it's just too complicated for us. And they're kind of setting aside the issue with racial gerrymandering, even though the way our party system oftentimes works is the racial component of it, particularly in certain states, especially when you're looking at states like Texas, where race and party oftentimes mirror each other. They're saying this is too complicated. So again, this is Rucho. And moving on, let's see. The district court's predominant intent prong is borrowed from the test used in racial gerrymandering. However, unlike racial-based decisions, which is inherently suspect, districting for some level of partisan advantage is not unconstitutional. Again, the court is trying to sidestep, this issue and saying, look, if it's somewhat legal, we don't really have to look into it. The district court also found partisan gerrymandering claims justiciable under First Amendment, coalescing around basic three-part test: proof of intent to the burden of individuals based on their voting history or party affiliation, an actual burden on political speech or association rights, and a causal link between the individual intent and actual burden. But their analysis offers no clear, manageable way of distinguishing permissible from impermissible partisan motivation. Again, just the court saying it's too complicated. And this is, again, we're just going to go over the syllabus real quick, and I've already taken up almost 10 minutes of time, but the conclusion that partisan gerrymandering claims are not justiciable neither condones excessive partisan gerrymandering nor condemns complaints about districting to echo and to avoid. Numerous states are actively addressing the issue through state constitutional amendments and legislation placing powers to draw electoral districts into the hands of independent commissions, mandating particular districting criteria for their map makers and prohibiting drawing districts for partisan advantage. The framers also gave Congress the power to do something about partisan gerrymandering in the Elections Clause. The avenue for reform established by the framers and used in Congress in the past remains open. Signed on by Roberts, and then Thomas, Alito, Gorsuch, Kavanaugh. And then let's take a quick look just at the, if I can find that really quick, I'd highlighted the dissent. I think actually I'm not going to do that in this video, but it strikes ironic that this court is saying in Rucho, this is 2018, we're not going to step into partisan gerrymandering because states are handling it with independent redistricting commissions. And now you fast forward to 2025, where you have our sitting president taking advantage of states who made an effort to get rid of partisan gerrymandering through independent redistricting commissions or bipartisan redistricting commissions, knowing that those states had their hands tied in being able to redistrict illegally. But states like Tennessee, or Texas and Indiana that don't have redistricting commissions, that's where Trump has pushed for redistricting, hoping, implicitly hoping that the states with redistricting commissions would be unable to respond. And that's the context that we need to keep here as we're looking at what's happening in this Texas opinion that recently came out by effectively the same Supreme Court. Since then, tragically, Justice Ginsburg died, and then Amy Coney Barrett took her seat. And let's not forget, I think it was 2016 when Mitch McConnell refused to allow Obama to replace a justice. So they effectively stole a seat on that Supreme Court. And that's the context that we're leading into now that we want to look at this recent Supreme Court opinion dealing with Texas. And again, part of the reason that I wanted to address this, because here in Virginia, our legislature, through a special session, just approved the ability to respond to Trump's redistricting war, and it's going to be voted on next year. And so I want the voters to understand, to be clear, I'm not a fan of partisan gerrymandering. I don't like this. I don't like that the feds, essentially Trump, has messed with our ability to run our state, but effectively by getting more seats in Texas and Indiana, the goal there is to mute out voters in Virginia ability to say we want to put a check on Trump. This is clear. There's no question about this. Donald Trump demanded more seats. The clear reason is he wants to protect his majority in the midterms. As you can see, this is December 7th. Just a few weeks ago, there was a huge rebuke of Trump in Virginia, as well as other states, New York. It was surprising, I think New Jersey as well, where they said, we're not going to put up with this. And so Trump knows that he needs to protect his majority, and the only way he can do it by cheating. And this is clear what we're talking about here is demanding Texas to give him more seats, and they ultimately acquiesced, and Texas got sued because of that. Ironically, the DOJ supported Texas' bid to redistrict. Of course, now they're suing California for their effort to respond in kind. And so we kind of see the bad faith in all of this. And tragically, I think what I see from the Supreme Court is just a court that is just going along with it. And it's just really tragic to see, especially I, as a student of the law, I'm a lawyer. I always wanted to be a lawyer. I dreamed of arguing in front of the Supreme Court of the United States. Now I don't really want to do a tour there because it's just hard to see what they're doing and not question the validity and the authenticity of the court. And this is a perfect example. So the case we're looking at now, Greg Abbott versus League of United Latin American Citizens. This is where Texas was sued for redistricting. And just a little bit, again, context there. Initially, Greg Abbott, the governor, did not want to redistrict. Then Trump had the DOJ send a letter saying, hey, we're essentially going to call into question your maps, implying there's some illegality there. And then that caused Greg Abbott to then puts through a map that greatly benefits Republicans and wins Trump his additional seats that he wanted. And then they got sued. And so now the court is being asked, they got sued. The district court said this is an illegal racial gerrymandering because effectively, in order to benefit Republicans, you've got to dilute minority votes. And so they sued upon that. And the Supreme Court, and they actually won a preliminary injunction. The Supreme Court has now stayed that preliminary injunction. And as you'll see in the concurring opinion, but also more important, the dissenting opinion, they had like a 9-day hearing where there was ton of witnesses that were heard about the racial gerrymandering in Texas, and the district court there made findings of facts that the Supreme Court is supposed to respect, and as you'll see, it didn't, but here we are. So again, in its shadow docket's essentially where they don't write a full written opinion. They don't give us, breadth of us to understand, what is going on. They just write an order, and here, and I'll put a link to this Supreme Court website here, so you can go look for yourself. And essentially, they just posted an order, and so you'll see here you got the documents filing. So this is the case filings, and you can see that. But if you go down December 4th, let's see if I can make this a little bigger. The application for the state presented to Justice Alito and by him referred to this court is granted, meaning we're going to stay the injunction by the district court. The November 18, 2025 order entered by the United States District Court for the Western District of Texas is stayed pending the timely filing of an appeal to this court. Should a notice an appeal jurisdiction statement be timely filed, this order shall remain in effect pending this court's appeal. So this shadow docket, this is essentially a one-page order that says we're not stepping in. The district court, sorry, we don't respect your opinion, and Texas, do what you got to do. And so now I wanted to actually look at the opinion itself, and I'll be honest with you, I kind of thought that as I was going to review this, it was going to take a little bit longer because I assumed that there was going to be a long written opinion. I mean, you saw Rucho, that was a 72-page opinion. And here, this concurring opinion is 3 pages long. I want you to see this. 3 pages, 1, 2, 3. And then the full document is 20 pages. So you have a 17-page dissent signed on by Justice Kagan, Sotomayor, and Justice Jackson. And of course, you probably understand who the concurring is. Not surprising. Let me make this bigger. Justice Alito, Justice Thomas, Justice Gorsuch. These are the ones writing this separate concurring opinion. And so let me just go through some of the important parts. Based on our preliminary evaluation of this case, Texas satisfies the traditional criteria of interim relief. Texas is likely to succeed on the merits of this claim that the district court committed at least 2 serious errors. First, the district court failed to honor the presumption of legislative good faith by construing ambiguous, direct, circumstantial evidence against the legislature. Just to be clear, again, nobody disputes this redistrict by Texas was kicked off by Trump. And to be clear, the impact is to dilute minority votes. I don't think there's any question there, but that is what it is. Second, the district court failed to draw a dispositive or near dispositive adverse inference against respondents, even though they did not produce a viable alternative map that met the state's avowedly partisan goals. So I guess in order for the challenger here is to have won, they must have essentially drawn an alternative map that gave Republicans additional votes that protected Trump's majority. Interesting. Texas has also made a strong showing of irreparable harm that the equities and the public interest favor it. This court has repeatedly emphasized that lower federal courts should not ordinarily alter election rules on the eve of the election. The district court violated this rule here. The district court inappropriately inserted itself into an active primary campaign, causing such confusion and upsetting the delicate federal-state balance in elections. Yeah, we're not on the eve of the election, and so they've essentially compressed the time. And also, when we're talking about the delicate state-federal balance, I mean, I can't think of a more disrupting behavior to that, disrupting impact or action to that balance is a sitting president demanding that a governor and governors redistrict in his favor. But again, we are where we're at. First, they also address they're trying to address the dissent where they have a lot of good points. First, the dissent does not dispute this because it is indisputable that the impetus for the adoption of Texas map, likely like the map subsequently adopted in California, was a partisan. It was partisan, pure and simple. And essentially, what they're saying, what the majority here is saying, or the concurring opinion is saying, this couldn't be racial gerrymandering because it was clear that that this was for partisan goals. So a little bit of interesting circular logic. And you know what? I also forgot to point out at the beginning of this, with an eye to the upcoming 2026 midterm election, several states in recent months have redrawn their congressional districts in ways that are predicted to favor states' predominant political party. Texas has adopted the first new map, then California responded with its own map for the stated purpose, counteracting what Texas had done. North Carolina followed suit, and the others followed suit. I forgot to mention this up from the jump. The court is not even saying, the majority court is not even saying Trump's name in the concurring opinion. It's essentially like, let's forget a huge fact that we're considering here when we all know what this is about. So obviously this is really playing curry to protect Trump, but it is, again, it is what it is. Let's see. Because of the correlation between the race and partisan preference, litigants can also easily claim use of racial gerrymandering for partisan ends. To prevent this, our precedents placed upon the burden to disentangle race and politics. Thus, when asserted reason for is political, it's critical for challengers to produce an alternative map that serves the state's allegedly partisan goals. Although respondents' experts could have easily produced such a map that were possible, they did not, given rise to strong inference the state's map was indeed partisan, not race. I'm just curious real quick. And what's interesting is I don't even think that they referenced their opinion in Rucho as I'm looking at this, even though obviously that had a big impact here. So let's go on to the dissent. Justice Kagan, with whom Justice Sotomayor, Justice Jackson joined. And I'm not going to go over the whole thing because it's 17 pages, but just a few big points. Over the course of 3 months, a 3-district court judge in Texas undertook to resolve the factual dispute at issue in this application. In enacting electoral map slanted towards Republicans, did Texas predominantly use race to draw its new district lines, or said otherwise, did Texas accomplish its partisan objectives by means of racial gerrymandering? The district court conducted a 9-day hearing, involved the testimony of nearly 24 witnesses, and the introduction of thousands of exhibits. Is sifted through the resulting factual records spanning some 3,000 pages. It assessed the credibility of each witness it had seen and heard, and after considering all the evidence, it held the answer was clear. Texas largely divided its citizens along racial lines to create new pro-Republican House map in violation of the constitutional 14th, 15th Amendment. The court issued a 160-page opinion recounting the details of factual findings. Yet this court reverts this judgment based upon its own perusal over a holiday weekend of a cold paper record. We are a higher court than the district court, but we are not a better one when it comes to making fact-based decisions. That's why we're supposed to use clear standard of review, clear error standard review. So what that means is we don't mess with the trial court's opinions unless there's a clear error. Why we were supposed to uphold the district court's decision that race-based line drawing occurred, even if that would have ruled different, even if we would have ruled differently, so long as it's plausible. Again, what the appellate court here, the Supreme Court is the ultimate appellate court. What Justice Kagan is saying is, we, for findings of facts, when there's what actually happened, when the court is investigating what actually happened, we are supposed to defer to that district court unless clear evidence is shown that they messed up, even if we would find facts differently, even if, so long as their factual findings plausible. Okay, that is a huge deference to a trial court that the Supreme Court is supposed to be giving to a district court, which Justice Kagan is saying they had a 9-day trial with multiple witnesses, thousands of exhibits, and over the weekend, this court essentially said, we're not agreeing with those facts. Um, um, Going on. Without so much as a word about the standard, this court announces that Texas may run next year's election with a map the district court have found violated all of our apt, repeated strictures about the use of race in districting. Today's order disrespects the work of the district court that did everything one could ask in its charge to put aside every consideration except for getting the issue right before it. And today's order deserves the millions of Texas whom the district court found were assigned to their new districts based on their race. Because of this, this court's precedents, our Constitution demands better. I respectfully resist. And so the court, the reason I'm looking at this is the dissent really lays out what we're talking about here. Kagan gets into what's actually going on. And so I'm not going to go through the whole thing. I'm going to post it to show notes so you can take a look, but just a few tidbits that I think are important. Recall the state of the world last spring. Before mid-decade, overtly partisan redistricting in both red and blue states became, I don't know how to say it, de rigueur. In those months, President Trump and his political team urged Texas officials to redraw their House maps with the goal of creating more Republican seats and protecting the party's vulnerable majority. The project was on no one's legislative agenda. Texas officials had created a new map per usual in response to population shifts revealed in the 2020 census, and those officials expected the state's next map per usual would follow 2030. A mid-decade redistricting absent some legal need was nearly unheard of, and although no one could challenge a partisan gerrymandering, our court in Rucho saw that voters could hold those supporting it to political account. Again, this was the innocent days prior to Texas redistricting, when partisan gerrymandering seemed undemocratic or at least unsavory rather than a mark of political conviction or loyalty. For those reasons, and perhaps for the fear of gerrymandering too. Gerrymandering is essentially a reference where if you try to get too fancy and cute with your redistricting for partisan gerrymandering, voters see what's happening and then they reject it, and you end up losing more than you thought to gain. So, and for those reasons, and perhaps for fear of gerrymandering, the Trump's administration campaign for a new partisan redistricting got little traction. So Trump is demanding things be done. They're saying no. With so little to show for its effort, the Trump administration switched tracks, converting its political inopportunity into legal demand. On July 7th, the Department of Justice Civil Rights Division sent to the Texas governor and attorney general a letter to serve as a formal notice describing this office's serious concern regarding legality of 4 of Texas's congressional districts. The letter focused on racial composition. With that letter, Texas's attitude changed once the administration's redistricting proposal came packaged as legal ultimatum to change composition. Texas embraced it 2 days after receiving the letter. The until then reluctant Governor Abbott issued a proclamation adding the following to the agenda for the upcoming legislative session: legislation that provides a revised congressional redistricting plan in light of congressional concerns. And in late August, the legislature acted a new map, one that both secured 5 more Republican seats and achieved all but one of the racial objectives that DOJ demanded. The map dismantled and left unrecognizable the district courts DOJ had the districts that DOJ later had identified, along with several similar districts, and it made 3 of those districts into a majority Black or majority Hispanic by the smallest amount possible, with a majority each coming in 50.2 and 50.5. Plaintiffs here challenged the new map as racial gerrymandering in violation of the 14th Amendment, but it was race, the plaintiffs argued, that gave a redistricting plan life by enabling state officials to present it as legal necessity rather than a partisan gambit. And most important, they contended it was race mainly that accounted for where new Republicans' friendly lines were drawn. Texas's only defense to racial gerrymandering claim was no such gerrymandering happened. In other words, Texas did not assert a compelling interest in drawing lines based on race. Texas has never argued that this is litigation. The DOJ letter was right, that it had a redistricting court of race to correct it. And Texas, of course, does not contend that the pursuit of partisan advancement itself is compelling interest. It is not. All Texas has ever said in response to plaintiff suit is that race had nothing to do with it, with its redistricting plan, even though, of course, as the district court found, that race really was the basis for the change. And I apologize. I should have maximized that so you could see it better. The dissent then kind of goes over the hearing. To do so, to support the district court's opinion, 9-day hearing, 23 witnesses, 1,000 exhibits. Watched many hours of videos, footage of legislators and Greg Abbott discussing proposed maps. After assessing the credibility of witnesses, weighing it, all the evidence, district court decided that the merits were clear-cut in favor of the plaintiffs. Substantial evidence revealed race predominated the action of redrawing a map, so the district court concluded in acting partisan interest, Texas racially gerrymandering the 2025 map. In support of that conclusion, the district court described 3 kinds of direct evidence strong that race played a predominant role. First, what triggered the redistricting commission was the administration reframing the request to do so partisan redistricting into racial terms. Here, the crucial fact was the DOJ letter. That letter, to be sure, did not specify exactly how Texas should rectify or correct its supposed illegal coalition of districts, but the court explained there is only one way to remedy district only objectionable characteristic, that is that no single racial group constitutes 50% majority. To redraw a district into a single racial group constitutes a 50% majority. DOJ imposed 50% racial target for 50 Texas to redraw the maps in certain districts. It thereby directed Texas to engage in racial gerrymandering. Second, district court described how the governor promptly asked the legislature to give DOJ racial rebalancing it wanted. So it's pretty clear what's going on there. And third, the district court found redistricting's primary bill sponsors repeatedly spoke in the same way. They suggested they had intentionally manipulated the lines to create more majority Hispanic and more majority Black districts. Effectively, what they call this is packing. So you pack in minorities to get the other districts. And it also addressed expert opinion here that was presented to the district court. And that conclusion was confirmed by expert opinion. One of the witnesses testified that she had generated tens of thousands of congressional maps that follow traditional districting criteria and favor Republicans by various metrics. In other words, that eschewed racial goals and racial data. The result, not one of them had racial demographics that looked anything like the 2025 map. The expert analysis thus supported what raw numbers it showed. It was once again highly unlikely that a legislator drawing a map based on partisan and other neutral considerations would have arrived the one Texas enacted. This court though, has not given significant deference to the district court. You would never guess from it the majority's order, but under this court's precedent, a district court fact-finding about electoral districts, most notably as to whether racial predominant district lines. Taking that standard seriously calls for denying Texas a stay application. In its 160 opinion, the district court marched methodically through its entire trial record. In asserting instead that the court's conclusion was implausible, Texas argues that because it was trying to maximize partisan advantage, it would have relegated all racial consideration to the side. Let's see. Also, Texas is not on the eve of the election, as were true in case majority side Republican National Convention versus DNC. The election there was 5 days after the injunction. Similarly, the election in Purcell was just weeks away. Here, election day is 11 months from now. Even the primary election, which Texas could change, is in March. The district court carefully listed various election preparations underway to switch to the 2025 map. On the other hand, the court now noted how the 2021 map, which was injunction reinstatement, was in real sense status quo. Officials, candidates, until last summer, everyone expected the map to govern 2026, and indeed, it will be used in a special runoff election in the state's largest county in 2026. The majority today loses sight of its proper role. It's supposed to review the district court's finding, and I think that's yes, that's pretty much. Let's see. And this court's eagerness to play act as a district court here has serious consequences. The majority calls it evaluation of this case preliminary. The results, though, will be anything but. This court's stay guarantees that Texas' new map, with all of its enhanced partisan advantage, will govern next year's election in the House of Representatives. And this court's stay ensures that many Texas citizens, for no good reason, will be placed in electoral districts because of their race. And the result is the court has pronounced year in and year out a violation of the Constitution. And so I think it's pretty clear. Anybody giving a good faith reading to the concurring opinion versus the dissenting opinion, it's clear who's giving good faith to district court's review and the fact-finding process. And it's clear what side of the court is being purely partisan. I mean, it's pretty obvious by doing this shadow docket, middle of the night type order, and then a 3-page concurring opinion, essentially just to give, it seems to me, almost talking points to Fox News and Republican Party in how to justify, how essentially recommending how they should argue this politically, which is it's just sad to see. Now, what does this have to do with Virginia? Right. And as I said at the jump, we just had elections here in Virginia where Trump was clearly rebuffed. And now the Democrats are using this mandate to say, look, the country, Virginia, the Commonwealth wants to respond to Texas. As I said from the jump, I was hoping that the Supreme Court would step in and just put a stop to all of it. Texas, you can't do it. California, you can't do it. Indiana, you can't do it. But it didn't. And so here we are. It is December 7th. We're getting ready to start legislative session in January. We've had a bunch of communications from Democratic leaders, Scott Servell and Senator Lucas, to just name a couple, that are all full steam ahead. And I think it makes absolute sense given that where we're at with this, because at the end of the day, if we don't respond in kind, Texas's votes will effectively mute out our votes. And that's not appropriate. And I really wish that we did not have to be here. I wish that the president would show respect for our Constitution, respect for states' elections. But I mean, after January 6th, I think it was pretty clear where he was going with that. It still surprises me he got reelected, but is what it is. But I also thought, in considering what Virginia should do, let's take a look at the resolution that was proposed and voted on recently. And let me switch over real quick, because I think it's also important to give context about what Virginia is doing. Just to be clear, Virginia, we are not going to be voting to disband the Redistricting Commission altogether. We're not doing that. It's going to be a very limited, narrow focus amendment. I do think the Redistricting Commission here in Virginia does need some modifications itself. I think, having gone through that process, I have a lot of critiques. I'm not against the process. I'm not against the notion of it, though. But number one, the way it's set up, I think inevitably it will go to the Supreme Court of Virginia, which I don't want to put them in that position to have to become a political beast, or at least minimize to be a political beast. But I think the way it's set up now, inevitably it's going to go to the courts. But that being said, also, this is a temporary fix to our Constitution, and hopefully it doesn't need to be used, but we're here. So let's take a look at it. And so this is House Joint Resolution 2006, offered October 28, 2025. It was recently passed. And so then this amendment will go to the voters. I think it's going to be voted on again. And then, assuming it passes, it will then go to the voters, and modifying our Constitution, where the Redistricting Commission was created, and then it'll modify. But the language that we're looking at here is Section 6 apportionment. The Commonwealth shall be reapportioned in electoral districts in accordance with the selection and Section 6A in the year 2021 and every 10 years thereafter, except that the General Assembly shall have authorized to modify one or more congressional districts at any point following the adoption of decennial reapportionment law, but prior to the next decennial consensus, in the event that any state of the United States of America conducts a redistricting of such states' congressional districts at any point following the state's adoption of a decennial reapportionment law for any purposes other than the completion of the state's decennial redistricting in response to a federal consensus reapportionment mandated by the Constitution of the United States or as ordered by a state or federal court to remedy unlawful or unconstitutional district map. So that is a very narrow conditional language that the Virginia General Assembly will be considering and will then be put up to Virginia voters, hopefully this year. And it's conditioned on another state like Texas behaving inappropriately. And so I don't like that this is the route that we have to take. I prefer not to be there. I will tell you, I'm a good governance guy. I think that even if that means that we lose elections, that I'd rather the process be maintained. I think the system is more important than individual policies, more important than individual parties, because at the end of the day, politics is going to swing left and right, and that's kind of the nature of it. I'm a far left Democrat. No one, not keeping that a secret, and never have. But at the end of the day, it is our system that protects us as a community, as a Commonwealth, and as a country. But when you have a president that has made it very clear that the goal here is for him to maintain power in the midterms, and then what happens if he's not checked in the midterms, I'm really fearful for our country. I'm fearful for our future. I'm fearful for my daughter's futures. So if you are a legislature watching this in Virginia, I support the redistricting efforts coming up in 2026. If you are a community member and you're on the fence and this makes you feel some way in your gut, it does me too. But you have to look at the context of what's happening here. You have to recognize that our Supreme Court is not going to save us. The Supreme Court has made it clear they've given Trump immunity. Now they've given parties immunity to just redistrict, and with the goal of essentially muting out opponents of Trump. I mean, that's really where we're at now. I always believed, while I didn't agree with Justice Roberts in a lot of ways, I always thought he was an institutionalist. But I mean, here we are, 2025, and he's just signed off on Trump demanding that you pack in minority voters to get him more seats. So I wish this video could be more positive. You may have questions, you may disagree. Feel free to comment below, and I'm always interested in talking about this issue intellectually. I have friends that disagree with what I'm saying here, and I absolutely respect their opinions. From an intellectual standpoint, if we're talking about good faith negotiation, good faith argument, I'm all above board on having those good faith efforts. The problem is we are no longer operating, at least in my view, in good faith territory. We have a party that is really crippled under the pressure of one man that I think is inherently corrupt. And I just hope that we all don't go down with the ship. He is almost 80 years old. The leaders behind of him, hopefully, political winds change. But all I can do is all I can do. And I think that we need to do this reluctantly. So feel free to ask questions, that kind of thing. Wish you guys the best. I get nothing. I'm not running for office, just running a law firm, trying to pay for my daughter's education. I just hope that our Commonwealth can stay safe. Wish you guys the best.